Dear colleagues, welcome. Very numerous, just in time. It's perfect for now. Our speakers are in time as well, which is remarkable. So we had the pleasure to organize in FFPE similar conferences last year, and we received a lot of comments asking for updating and having again the opportunity to listen to our specialists from Cabinet de Keyser. So we did with a slightly different format. Last year, what we did with them was a presentation of succession law and donation. So the legal aspects first, and in a separate conference of the fiscal consequences. And we thought that maybe it was a bit confusing because the two are obviously entangled when we make decisions on the legal elements of your succession or donation. You want to know in advance also what will be the fiscal consequences. So this time we've been organizing both in French and English two conferences. The first one on successions, the one we're going to have today, addressing simultaneously the legal elements and possibilities that you have to opt for one or several different legal framework, and at the same time to address the fiscal consequences. And the new conference in English as well on donation with the two aspects will be organized, I believe, but you will receive on the 12th of June, but you will receive an invitation. Okay, so I just have to introduce again my password. And that's it. Here it is, and I can give the floor to Frank de Keyser. He will introduce his cabinet and start the presentation. The floor is yours.
Thank you, Mr. Bakri.
Thank you, Mr. Bakri. It's good to see so many faces. Thank you for having come. So, let me introduce briefly ourselves. So we are a law firm based in Brussels. We're a few lawyers specialized in tax law, and more specifically in estate law, meaning civil and tax aspects of related to the way of organizing purchases, sales, or gifts and inheritance. The civil aspects are, as I will repeat later on, how to give. Should I make a contract? Should I go to a notary public? Who will be my heirs? What are they entitled to? Will they receive, when I pass away, full property, bare ownership, usufruct of which portion of my estate? Or may I draft a will and contradict in a way what the law provides? These are the civil aspects. When people request our assistance, our fees are billed on an hourly basis. Usually to have a meeting it takes only 10, 12 days. And when it is possible, we propose lump sums. When we can estimate the work to be done, when we can estimate the time that will be devoted to the case, then we propose a lump sum. Otherwise, we just bill on an hourly basis. Now, to start with the agenda, today our time will be devoted, as Mr. Bakri said, to the inheritance issues, not to gifts. And we will first go through the agenda. Thank you. So the civil aspects address the issue of who are my heirs and what are they entitled to. We will analyze European regulation in force since August 2015 that make it possible to choose the civil law applicable to your estate. Previously, people had no choice in Europe. They had to, the law applicable to their estate was the law of the country where they were residing at the time of their death. Today, we can choose, and we will come back to this, the law of either the nationality or of the country that they are usual residents of. I'll come back to that. And then, thank you. The tax aspects will address the issues of what are the criteria for the taxation of inheritance. What are the criteria? Is it where the deceased lived? Is it where the heirs live? Is it where the assets are located? Is it possible to legally reduce these taxes? How to do? Is it possible to, well, are there situations of double imposition, of double taxation, or triple taxation? Is it possible to avoid them? And Antoine will address the local foreign issues, which laws, he would point out the differences, the main differences, either in the civil laws or the tax laws for a few countries in Europe. We have not chosen France, since even if most of you may speak French, there was already a conference like this in French, so probably countries like the UK, Poland, Croatia will be more useful. That is what he will do. And we will analyze more deeply Belgian tax laws, civil and tax laws. As you will appreciate, it might be the case for most of you that Belgian civil laws will apply to your estate, even if you are UK nationals, if you plan to, or if you plan to buy a house in Portugal, and if your children live in Spain, you are usual residents of Belgium today, and some of you might stay in Belgium after retirement, which will make these local laws applicable, civil Belgian laws. So we have, no, it's okay, thank you. We have a choice today. If the deceased is a usual resident of a country, of a European country, he can choose the law of his country of citizenship, his nationality, either the nationality at the time of the choice, meaning in most cases when he drafts his will. At that time he's a UK citizen. He or she can choose UK civil law. Or he can choose the law of his citizenship at the time when he passes away. It can happen that people have, for instance, or are moving, changing, from one nationality to the other one. They know that except if they die tomorrow, they will have another nationality in a few months, or they have a double nationality and they are in the process of renouncing to one of them. So if it is not the law when the person drafts his will, it can be the law of his nationality when he passes away. If no choice is made, then the applicable law will be the one of the country where he usually stays, his country of usual residence at the time of his death. Just a few words on the case, about the case where the deceased is not a usual resident of a European country. It could be the case of some of you. It's not a usual situation, but it can happen. In that case, where it's a bit more complicated, but let's take the example of an American. An American would have assets in a European country, and either he has been a resident of this country for some time during the last 5 years, or he is a citizen of this country. For instance, the American owns a house in Portugal, and he's a Portuguese, but he lives in the States. Then he could choose the Portuguese law as being applicable to the civil Portuguese law, as being applicable to his estate, even if he lives in the United States. But the condition, if the conditions are met, he owns something in Portugal and he's either a Portuguese citizen or he has been a resident of Portugal for some time during the last 5 years. In that case, Portuguese law could apply to all his estate, even to the assets in the United States, assets in Britain, assets in Africa. Of course, as most of you probably already think about, the United States will not accept to apply Portuguese law to, for instance, real estate in the United States. Then there is no treaty addressing this situation, which is not a tax situation. We will come to the tax treaties later on. Then in the internal, well, in the local laws, in the American law, in Portuguese law, there are usually provisions organizing the way to decide which law is applicable. What we can say here, starting from the European regulation, is that Portuguese law could be applicable to the whole estate of this person. Then, if the heirs agree, or if all of them agree to apply Portuguese law, because what is provided is convenient for them, for instance, that the father or the surviving father or surviving mother will have, for instance, the usufruct of the estate, and that the children will have the same share in their ownership. There are 2, 3, 4 children, and they agree that this is fine. They could choose to apply Portuguese law, and then the United States will not contest that, because they have no interest in contesting. But if one of the children says, no, I want to have American law applicable because then a surviving father or surviving mother does not receive anything, which is not the case, but let's take the example. Then he could go to court and ask for the American law to be applicable. And then usually, it's surprising in 2019, but usually it is the laws of the country of, if I can put it that way, of the courts that have been seized. These laws will be applicable. In this case, if the child living in the United States go to an American court, to a jurisdiction, and says, my sisters and brothers want to apply Portuguese law, I don't agree. American judge will say, American law will apply to the estate in America, or even to the whole estate. If another child goes to the Portuguese court, the Portuguese judge would say, we apply Portuguese law. Okay, I close this point. Now, yes, if there is no property at all situated in a European country, this is the last line on the slide there, then this European regulation does not apply at all. Okay? Now, so the European regulation, that is mainly of interest for you if you are usual residents of a European country. You can choose either the laws of your country, of your citizenship, what I said earlier, or the laws of your the country of your usual residence at the time of your death. So that is what may be in most cases of interest to you. It is needed to explain what it means being a usual resident. I can start by saying that you are today usual residents of Belgium. So if any one of you had an accident tomorrow Belgian civil laws would apply if you have made no choice in a will. What does it mean to be a usual resident? It is an autonomous notion. So this notion is determined, is explained in the regulation. There are three material conditions. One is, what is the country where you have your personal and family interest, meaning where does your spouse or partner live? Where are your children? Are you a member of a tennis club? Are you a chess competitor? And which country are you mainly known? Do you play? For a man, where are your suits? For a woman, where are your dresses? This is the country where someone has his personal or family interest. Then the second criteria is, where is your job performed? Of course, here in your case, for most of you, it's in Brussels, in Belgium. And then, where are your assets located? And if you have assets all over Europe, where are located most of them? Okay, these are the material conditions. And then you have a subjective condition, which is where the deceased, where did he show that he had the intention to stay? To have a stable and permanent center of interest. Because if he has stayed for the last 6 months in Madeira, a very nice island belonging to Portugal, that doesn't mean that he had the intention of having his permanent center of interest there, even if he found a job for 6 months there, even if he went there with his partner, even if the children aged 2 or 3 years old who do not go to school have accompanied their parents. Okay. Subjective condition would not be fulfilled. I want to draw your attention on the fact that this residence, this usual residence, has nothing to do with your tax residence. We'll come back to the notion of tax residence later today. Protocol number 7 of 2012 provides for rules stating that your tax residence is based in your country of recruitment. This has nothing to do with what we are talking about now, which is which civil law will apply to my estate. And it will be the laws. Now, if I am a usual resident of a European country, then the regulation will apply. If regulation applies, I am dead by hypothesis, or did the deceased make a choice according to his or her nationality? If he did not, then it will be the country where he resided when he passed away. Yes, thank you. The regulation is very useful and was a huge progress from a legal point of view, because it provides that only one law will apply to the whole estate. Until 2015, the inheritances were split. Were split between the different countries where the assets were located. Someone had a house in France, and then when he saw the Gilets jaunes arriving, he bought another holiday house in Portugal again. And he was very, very careful about his money, and he thought it was better to have his money in pounds in London. And then he died. And he died in Belgium. Belgian civil law is no more the case, but it was applicable to all his assets, globally, to all the assets. But then Belgium recognized that French law could be applied if the heirs asked that. It could be applied to the house in France, Portuguese law to the house in Portugal, and British law to the bank account in London. the regulation of 2015, of 2012, but applicable since 15, states that only one law will apply to the whole estate. Even if some of the assets are located in a non-European country. In my previous example, even if some assets are located in the United States, if you remember the example. So now, how to express my choice? There are different ways to do that. The most obvious one is in a will. So in a will, and then you have to draft the will according to the laws of the country that you choose. Except again, if you say, I draft the will in Belgium and I want Belgian laws to apply to the format of the will, and the other rules, what will my heir receive and so on, according to a Spanish law or a UK law. But so, to make it simple, you can draft a will, and choose the applicable law. Usually the will be drafted according to the chosen law. If it is in Belgium, you can draft a will by yourself. You can make it one evening with a glass of wine, and you can put it under the mattress, and hopefully someone will find it, and this will be applicable. Or you can do it with a lawyer like us. We are no notary public. You can do it with a lawyer to have it well, sort of for the legal security. And then either you keep it, the lawyer keeps it, or we register it in a central register, a register at the European level, so that even if your heirs are in another country when you die, even if they choose a notary public in that country, in the UK for instance, the person in charge in the UK will have a look in the register to see whether there is a will and where this will is. Okay, it was registered in Brussels. I can ask a copy of it. Or you do it with notary public. Of course, there are no notary publics in all the countries in Europe, but whatever, in Belgium you have. And that is, I have, the last line here addresses one specific issue, which is the reserved portion of an inheritance. You probably know that in many countries, including Belgium, part of your assets has to be distributed to your children or your partner. They are entitled, well, we'll come back to that, but what I wanted to say is that if you choose a law that does not recognize the reserved portion, it was a question until 2 years ago as to whether Belgium would recognize this law, which does not provide for a reserved portion, or whether Belgium would accept that. For instance, the UK law, which does not provide for a reserved portion for the spouse, if I'm right, and the person who would pass away in Belgium has chosen UK law, and the children do not receive anything because he has bequeathed his assets to everything to his children. Would Belgium accept that? Well, the reply now is yes. You have a few countries who do not. We had a case 2 or 3 weeks ago of someone, well, the one who came to us was the son of a couple. The mother has died, and the two parents, the mother and father, had chosen to be considered as tax residents of Monaco. So they are supposed to be residents, well, really residents of Monaco. Actually, I suppose they live in a mailbox, but anyway. And they want to give all their assets to the surviving spouse and nothing to their son. Well, they have not seen their son for a few years, the one who came to us. And so we have checked what the legislation is in Monaco with regard to the reserved portion. And it happens to be that in Monaco there is a reserved portion for the children. So these persons, father and mother, have chosen the laws of Monaco, and they wanted to, so they have made a will, the mother who died made a will, stating that everything goes to her spouse. And actually the son will ask for a portion of the estate, and the courts of Monaco will recognize his rights. If they had chosen Belgian laws, the reserved portion would have applied, but they could have chosen another country where there is, like the UK, like Luxembourg, where there is no reserved portion, and where there is a reserved portion, but not of public order, which is not mandatory. Okay. Yes. Now. Okay, Antoine, take the stage.
Okay, so hello everyone. So I'll now present Belgian civil law. So it might be relevant for you since if you are deemed to be usual resident of Belgium at the time of your death, Belgian civil law will apply per default. Or if you have chosen in a will Belgian law to be applicable to your estate because you think that the Belgian rules are convenient for you. There has been a reform of the Belgian law that is in force since September 2018. Of course, the presentation is based on the new rules. It's just important to know that that we have reformed our laws because they were a bit outdated. They dated back from Napoleon, and so now they have been modernized to be more aligned on the new type of families that we see in 2019. So they take into consideration blended families. There's also a bigger part of the estate that can be freely given to anyone. So the reserved portion of the children, for instance, is now limited to 50% maximum of one's estate, while before it could be higher depending on the number of children. This being said, so what is the basic devolution in Belgium? If you die and you haven't prepared a will, we have what we call a legal inheritance devolution that will take place. In this case, the spouse, if you are married, of course, the spouse will receive the usufruct of the entire estate, and the children will receive the bare ownership. I said if you are married, but we also take into consideration, of course, legal partners or cohabitants de fait, as we call in Belgium. So the partner will receive the usufruct and the children the bare ownership. It is possible to deviate from this distribution of estate either in a will or in an inheritance agreement. So in Belgium, on the contrary to some other countries, so we know what we call reserved portion, portion héréditaire in French. So these are parts of your estate that you have to leave to your legal heirs, which are the spouse and the children. So even if you write a will and you say, I give my entire estate to my neighbor or to my friend or to my spouse, if you have children, they will be entitled to receive altogether half of the estate. So all the gifts that you may have done which exceed half of your estate will be reduced proportionally to respect the rights of your legal heirs. Also, the spouse, partner, has a reserved portion which represents half of your estate in usufruct, and that half will be imputed on the available portion of the estate. So to avoid that there is a conflict between the children and the partner or the spouse, his or her usufruct will apply to the available portion, not on the portion that is reserved for the children. And also there is a dedicated reserve that is the conjugal or the family home that must also go in usufruct to the spouse. If the family home is worth, for instance, is the only asset left in the deceased estate, which can be the case, or if the value of the house is very considerable in comparison with the other assets left by the deceased, it can happen that the usufruct of the spouse will be 90 or 100% of the entire estate, and in that case, the children will only inherit the bare ownership until the surviving spouse or partner dies. Also, I didn't mention, but so in Belgium, the estate that is taken into consideration at the time of the death is not only the assets left at the time of the death, but also, so as I said, all the gifts made by the deceased during his lifetime, which will also be added to the estate to calculate what rights do the heirs have in the inheritance, and also some what we call legal fictions in French, which are assets that have been that are not owned anymore by the deceased at the time of his death. For instance, if he invested money in a life insurance, so that money went to the life insurance company to the benefit of his children, for instance, we will also take into account the capital invested in such insurance policies to determine what's the total estate of the deceased. So these rights have to be respected in a will. I mean, all the rights that are not respected will have to be reduced proportionally to be respected. Or another solution, if you want to give more to some heirs than what the laws provide for, if the other heirs agree, you can conclude with all your children, for instance, what we call an inheritance agreement. So it is something new since last year in Belgium. Before 2018, it was not possible to conclude such an agreement, while it is possible in other countries, like in France, for instance. But so now you can bring all your heirs around a table, and if you agree, you can determine what will each of them receive when you die. So, and it can also infringes their reserved portion if they agree to. So one can agree to be fully disinherited, for instance. But there is quite well, not complex, but there is a procedure that needs to be followed so that everyone is really aware of what concessions he's making. So that's what's represented on this slide. So you see that it will take up to 2 months at least to reach the final agreement with all the heirs, and there are mandatory meetings to discuss with a lawyer and with a public notary the agreement that will be signed. I will now compare Belgian civil laws with the laws of other EU member states. The purpose of this is to illustrate the big differences that can exist between the different laws of the various member states, because as we said, in some situations you can choose the law of your country of nationality to apply instead of the law of your usual residence, but sometimes you would actually prefer the law of your usual residence to apply, and you would prefer so not to make the choice of your country of origin. So this is based on all the different rules in each country. For instance, France, I will not go through France, but I can just say for France that what is interesting in France compared to Belgium, for instance, is that in France you don't have a reserved portion for the partner, only for the children. So if there are children, you may give all your estate to your children and nothing to your spouse. Sometimes you would like to do that, so that's possible there. In Belgium it is not. If there are no children, then the spouse will be entitled to a small fraction of your estate. In England, it is a bit different. If you haven't drafted a will, if you haven't left a will, then the spouse will inherit most of the assets of the deceased. I won't list them, but it represents the biggest part of the pie here, and the children will inherit the 1/4 of the remaining estate, which is a small fraction. But you can draft a will where you give all your estate to your children, or all your estate to your spouse, or all your estate to a friend, because in England there is full freedom for the will. So there are no reserved portions like in France or like in Belgium. In England you are totally free to do so. We have also specified that it is forbidden in England, but also in Belgium and in France, to draft a joint will, which is, so if you are a couple and you would like to draft a will, each of the spouses must draft a separate will. You cannot draft one document distributing the estate of the couple, because that will be considered as null and void, while in other countries, in some countries actually, like in Germany for instance, it is authorized, it is permitted. So if you want to draft a joint will, you need to cross the Rhine and go to a public notary there and draft the will according to German law. And finally, it is also permitted to draft an inheritance agreement in England. In Germany, to continue with Germany, so what is interesting, so as I said, is the fact that you can draft a joint will.
Can I make a
yes?
The printouts don't have a lot of information.
Oh yes, I didn't mention that. So yeah, we distributed printouts which have the you have all the structures, so you can take notes. It's more convenient to take notes, but it's not the full presentation. So yeah, it's a good point. So you can take notes.
Will we get the full presentation?
So what is interesting here is, so we said you can choose the law of your nationality. Let's take an example. You have a couple. It's a German and a Spanish, originally very conveniently from Navarra. I will let you explain to you later why. But they want they want Spanish law to apply to both their estates, to the estate of the German and to the estate of the Spanish. The German does not have Spanish citizenship, and they both live in Belgium, so their usual residence is Belgium, but they can choose the law of their nationality, and they want the law of the nationality of one of the spouses to apply to their entire estate. What they can do is they can go to Germany, where it is possible to draft a joint will, and specify in that joint will that Spanish law will govern the entire estate. And by doing so, if they take, for instance, the law of Navarra, if the spouse who is Spanish is originally from Navarra, it will be the law of that community that will apply. So if the law of Navarra applies, for instance, in Navarra you don't have any reserved portions. So by doing so, that couple can give freely all their estate to whoever they want. So that's permitted. It's a bit tricky, but you can achieve that kind of result by...
Yes, I have a question.
Yes.
What in cases of several relations... Sorry.
Yes. Yes.
What in cases of several marriages or relationship, when we have a joint will which was agreed and divorced once, and we get divorced, and we get another one? What happens?
Maybe we go in detailed questions later on, because we have after a presentation, otherwise everybody will start putting questions, and the best is to finish the presentation and then we will address questions. We have a question and answer session.
Okay, but we'll come back to this at the end. So this was a good example for why it could be relevant to go to Germany to draft a will. So I have other countries in the slides. I will not do them all. We can continue with Poland, maybe. Yeah, Poland. So in Poland, I'll just say that. So in the absence, if you haven't left a will, so in the absence of a will, it's very easy. The rule is that your estate will be divided equally between. In our example, so there is one spouse and two children. It will be divided equally among the three of them, and they are also entitled to reserved portions. So if you have left a will, they are entitled to receive at least half of what they would have received in the absence of a will. So in this case, they would be entitled to receive each at least 1/6 of the estate. It is quite similar to what would be to what would apply under Croatian law or under Slovakian law. So in these two countries, it's the same rule. So in the absence of a will, the estate is divided equally amongst the spouse and the children, except that in Slovakia, under Slovakian law, the spouse does not have a reserved portion of the estate. So if you have prepared a will, you can give all your estate to your children, or only part of the estate to your children, and the remaining part to a friend, for instance, and nothing to your spouse, which is not possible under Croatian or Polish law, for instance. And then we have a few Latin countries that we already presented in the French version, and I will not be too long on them. It is only important to speak about Spanish estate law, because in Spain you have something very particular. It is that Spain is divided into 17 autonomous communities. So in Belgium we have 3 communities, in Spain it is 17 communities, which make it even more complex. And you have federal rules, but the autonomous communities can deviate from these federal civil rules and have their own rules. And you have big differences amongst the 17 communities. So for instance, as I said earlier, in Navarra, you don't have any reserved portions for the heirs, while if you apply the federal rules, there are reserved portions, as we show in this complex graph here, for the children and for the spouse. So if you plan to move to Spain for your retirement, and you think that you may have a Spanish law apply to your estate at the time of your death, you should consider your choice of the choice of where you plan to live in Spain, because it will have an impact on what your heirs will be entitled to receive in your estate. So why we gave you these few examples of the civil rules in other EU member states, it is because if you go there for your retirement, as I said, and you die there, you can choose that law to the law of these countries to apply. So if you go live in Croatia, as we said, you know that your spouse will be entitled to, in our example, 1/6 of your estate. If you don't want to leave anything to your spouse, then you should move to Navarra or to England, where there is no reserved portion. The same for your children. If your children were mean to you, then you could also go to England or another country. But so it is good to know all these different rules, because now, because of the new regulation since 2015, you can play with the different laws of the different member states, which was not possible in the past. It is not a member of, did not adapt this regulation. Yeah. Just for your information, Denmark, Ireland, and the UK did not adapt it. Yeah. Also, we took a few examples with the UK because the judges, the tribunals will follow the choice, will generally follow the choice in a will, the choice of law in a will in the UK or in Belgium. If you choose a UK law in a will, it will apply, but they are not.
Denmark, will it apply for Denmark?
But not for Denmark. It's I mean, I know for the UK, I'm not sure for Denmark because they are not a member of this regulation.
There was no ruling then. There was no ruling yet.
Yeah.
And taxation of, let's say, of international inheritances. The external factors to take into consideration for inheritance purposes are, or may be, the nationality of either the deceased or the heirs. So now we speak of taxation. You can put into brackets what we have said until now. Nationality is of no use. Nationality of either the deceased or the heirs, but it is a criteria that come to the mind. The residence of the heirs is sometimes relevant, for instance in Spain, for instance in Germany. If the heirs live in Germany or live in Spain, these countries will consider they are entitled to tax the portion of the estate that is given to the local resident. The residence of the deceased is a criteria that is relevant in all countries. So whatever country you live in Britain, you live in Spain, you live in Belgium, you live in Croatia, the deceased lives there. This country will be entitled to tax the estate. And the location of the inherited property is sometimes relevant, sometimes not. It is always relevant for real estate properties. So I have a house in Verone. Italy will tax the inheritance of this house. So it will be relevant in all the countries in Europe. Where the movable properties are located is usually not relevant. It might be, like in France, if you have a pile of banknotes in your vacation house in Saint-Tropez, this is taxable in France, even if you are a resident of Belgium or a resident of the UK, whatever. And then the place of death is not relevant. So you can be on holidays in France, but you are a usual resident of Belgium. France is not entitled to tax, except for what you own there. But the place of death is not relevant. So you can die during your holidays, it doesn't matter. Now, which elements are really relevant and how to proceed? Yes, thank you.
Mr. Roland.
European officials are subject to Protocol number 7 of 2012. This protocol provides for different criteria. An active official in Brussels and his non-working spouse and his or her dependent children will benefit from the protocol. And that means that for tax purposes, the country of recruitment of the official is the country that will be entitled to tax the inheritance. So you have been hired in Poland and you stay in Brussels and you pass away during your career with the European Commission or Council. Polish tax law will be applicable. If you retire, as one can hope so, if you die when after having retired, then it will be the country where you live at the time when you pass away that will be competent to tax. If you stay in Belgium, which happens to many people, I think, so you retire, you stay in Belgium, and then you die when being a resident of Belgium, the protocol does no longer apply. So Belgium will be the country entitled to tax your estate. You also have the information about gifts, because this might be useful. We will come back to that on June 12th. But it's useful to have the working spouse does not benefit from the protocol. Working spouse is the one who does not work for a European institution. So someone, let's say a man has been hired in his country of origin, in Poland, he comes here, he works here. His wife comes to Belgium, she does not work, but she doesn't speak French or Flemish, she doesn't find it work, she's not interested in working for the Commission. She will benefit from the protocol. But suddenly she discovers she has talent and she becomes an architecte d'intérieur, a designer, and she works as a self-employed person or even as an employee in a private firm. She will no longer benefit from the protocol. So when she will die, Belgium will be competent to tax her estate. But when he dies, it will be Poland.
But your tax residence is somewhere in CISPER, so that's the reference to be taken into consideration. But we'll come to detailed questions later on.
Okay. So there is a risk of double taxation or triple. I'll give you an example. Well, a retired official who has worked in Belgium, he was recruited in Paris. When he passes away, he owns a holiday house in Spain, and his heirs are residing in France. So Belgium will consider that this country is entitled to tax the whole estate. But Spain will say, we tax the value of the house in Spain because it is located in the territory of Spain. France will say, we tax because the children live in France. If one of the children was also living in Spain, it would be another reason to tax in Spain. So who will tax at the end? All these three countries consider themselves as competent to levy taxes. The remedy, the main remedy, or there are two remedies. The formal one is the tax treaties between all these countries. So Belgium will say, I am the one entitled to tax the whole estate because this person was a resident of Belgium when he passed away. And I know that Spain will tax the real estate in Spain, because it's a usual rule. So I agree to deduct the Spanish taxes that my resident paid in Spain. France will say, well, I also tax because one of the children lives in France. And then there is only one choice. It's to hope to have a tax treaty, or to have, and there is a tax treaty between Belgium and France, by the way. We have only two treaties, one with France, one with Sweden. Otherwise, one has to hope that France will have in its internal legislation a provision stating that they will not apply that provision making the country competent to tax because the heirs live there. If not, both countries will tax. In that case, the remedy is to organize, to plan his or her estate. So to or to organize one's assets so that you do not have that situation. So that means I will choose, or I will maybe say to my children, either you leave France, or France is not a good example with Belgium, but Spain, for instance, is a good example because we have no treaty with Spain. I say to the children, you leave Spain. Or I will say, okay, Mum and I, we have a holiday house in Spain. We will register ourselves with the population in Madrid and no more in Brussels. Or we will sell our house, or we will give our house in Spain to our children. We will give it so that it is no more a part of our estate. Well, all these possibilities that we will discuss actually on June the 12th, how to do to avoid double or triple taxation, or credible taxation, it also happens. So that's it. Yeah, thank you. Now what about Belgian inheritance laws, so tax laws? Belgian law is of particular interest. It is not because we are now in Brussels and we are Belgian lawyers. We actually work also with our lawyers in all 28 countries. The other countries. But Belgium will be of particular interest because a certain number of you will stay in Belgium after having retired. Because you could have your children here, most of your assets here, and maintain them here, even if you move to another country. You move to your country of origin, but you keep your apartment in Brussels or your house in the Ardennes. Again, Belgian tax laws could apply. So what do they provide? First, if you are a resident of Belgium when you pass away, Belgium will tax your worldwide estate, as Antoine said earlier, your estate when you die, and legal fictions, what you have put into an insurance company to be paid after your death to your children or your spouse will be taxed. Or what you have purchased, the real estate you have purchased. The real estate you have purchased in usufruct for you and your spouse, in bare ownership with your children. The children bought the bare ownership of your apartment, and you and your spouse the usufruct. In some cases, when this is not organized in a proper way, the full ownership will be taxable in your estate. The rate are these ones, but you can have a look at them in the documentation you received. The persons liable for these taxes are the beneficiaries, individually. One can always accept an inheritance subject to the benefit of looking into it. What we call in French bénéfice d'inventaire. So having the right, to first have a look. What are the assets? What are the liabilities? If the assets are higher than the liabilities, I accept. Otherwise, I don't. Now, if you are we will argue questions later on. Please, sorry. If you are probably all of you, at least most of you, today active officials working for a European institution, and most of you have not been recruited in Belgium. Sorry for you. Not been recruited in Belgium, so you are subject to the taxes of your country of recruitment. But you own a property in Belgium. So Belgian taxes will be due. They are not called droit de succession, inheritance taxes, but it's the same. The rates are the same. It's just transfer taxes. The rates are absolutely the same. So that's it. The rates, we have already gone through them. And yes, I'll pass you the floor. Okay.
So this slide is just to show you that so when there are elements linking one estate to the tax laws of different countries, as Manuel said, there is a risk of double or triple taxation. So the two ways to avoid this, as we said, is either you have a treaty that provides for a solution for this to avoid this double taxation, or you have internal solutions in the laws of the relevant countries. There are no treaties with all countries. There are less treaties for inheritance taxes, for instance, than for income taxes. So for income taxes, most countries have concluded a lot of treaties, bilateral treaties. For inheritance taxes, Belgium, for instance, has a very, very poor network of treaties. It only has 2 treaties with France and with Sweden, dating back from the 60s, so quite old. For all, if we have a double taxation with another country than Sweden or France, we will have to find a solution in internal law of Belgium or of that other country. Other countries like UK, Germany, France, and other countries have a broader network. So for each case, we'll have to look: is there a treaty? If there is no treaty, then we'll have to look into the internal laws. So I prepared a small case here with so it's always the same case. We have one person who dies and who leaves behind one spouse. I can just switch the. Yes. So the deceased has one surviving spouse and 2 children. It is interesting to see how different the tax treatment will be depending on which country will tax the estate. If we take, for instance, England, in England the spouse will be exempt from inheritance taxes and also exempt from taxes on the home. But so, as we saw earlier, under UK common law, the spouse will, per default, inherit the biggest part of the pie, and will not be taxed on this inheritance. So this is very interesting for the spouse in the UK. In France, there is also no inheritance tax on inheritances between partners. So most French people, what they would do is they would give their entire estate to their spouse with no tax, and then the spouse can live 10-20 years with the entire estate, and then pass it to his or her children. And then there would be taxes, because between parents and children in France you have rates ranging between 5 and 45%, for instance. We'll not go through all the various member states, but we can also say that in Italy, for instance, since Berlusconi, the tax rates are very favorable for spouses and children. There is a flat rate of only 4% inheritance tax applicable, plus you can benefit from a tax allowance of 1 million euros. So most people in Italy will not pay any inheritance tax there. Same in Spain, where you have so the different tax laws of the different communities, and in some communities you will have tax allowances up to 1 million euro, or up to 99% of your estate, and so on. You will have to look at the internal tax laws in that case. And yes, so in Poland now, in Poland you don't have any inheritance taxes between for spouses and children, subject to some conditions. Other countries like Sweden abolished totally inheritance taxes, so there you will not have to pay any inheritance taxes. The same for Croatia here, Portugal, where you will not have any inheritance tax for children and spouses. So this is just to illustrate how different the tax laws, the tax result will be. And depending on this, you can also choose to to take your retirement in Portugal or in Italy, for instance, if you want your heirs not to pay too much tax, or if you plan to move there, what we will see in the next presentation is if you are deemed to be tax resident of Belgium, you could give all your estate to your children while being in Belgium, because in Belgium we don't have, you can make a gift of movable assets with no limit, tax-free, which is not possible in all countries. So you can do this kind of optimizations, take some legal steps while living in Belgium or another country before moving to another. That's the purpose of this presentation. And so the next session will be gifts in an international context, and we will also talk about all the alternatives to gifts that you can think of, like investing into life insurances. Sometimes it can be very favorable, or in Belgium where we also have this private foundation, which can also be useful depending on your objectives. So now we will have a time for your questions. And I will
Thank you very much first for the speakers.
So in Belgium we have progressive tax rates. So the tax rate that you will have to pay depends on the link between the deceased and the heir. So if it is an inheritance between parents and children, you will be in the first line. So in Brussels you would have to pay 3 to 30% depending on the amount of the inheritance. And in Flanders they have lowered the rate a few months ago, so now it's 3 to 27%. We hope that the other regions will align on this, which is usually the case in Belgium. You have one region which lowers the rates, and then the other regions just follow. It's a good competition between them. But you can also see that between third parties, which mean if you leave your estate in a will, for instance, to a friend or to a grandnephew, or to someone of your far family, the rate can climb up to 80% in Brussels and in Wallonia, which is very, very high. In Flanders, it is now maximum 55%. But so that's the explanation on the rates, and the tax rate that will apply depends on the region where the deceased lived.
The house you have bought with your partner is either a joint property if you are married. Well, if you married in Belgium with no contract, it will be the communauté de biens. If you married in another country, then it will be the legal regime that will be applicable, the legal regime of this country, the Polish regime, the Spanish regime, and so on. Which can be, in most countries, it will be the communauté de biens. In some countries, it will be the séparation de biens. So it does not depend upon the tax authorities here. It will depend upon the civil law applicable to the situation. Then, if, according to the civil law, part of the house belongs to the partner who died, well, this part of the house will be subject to inheritance taxes. If the house is in Belgium, it will be in Belgium. If it is abroad, it will be the tax laws of this country. So there is a first stage, which is who is the owner of the house. So who bought, who is mentioned as the buyer of the house, of the apartment. Then what is the legal regime if these people are married? If they are not married but in a pax, you know, like in France. Anyway, the reply is the same for everybody.
That's my question.
The reply is the same for everybody. First you have to look under civil law, who are the owners? If you married en régime de communauté de biens, according to Spanish law, Polish law, Belgian law, whatever, the house bought by the two partners, or even by one partner, but with money earned during the time of the marriage, this house will be considered joint property. Okay? Because Belgium accept, like most countries, to apply the regulation even to citizens of Denmark, Britain and Ireland.
So suppose you are an official, so resident in Belgium, and your family is in Italy, but you are resident for tax purposes in the UK, you were recruited in the UK. So your parents die, so the state, you know, the taxation is done in Italy because, you know, the parent was living in Italy and all the properties in Italy. Because of Protocol 7, could the UK claim some taxation on the amount you receive?
If you are considered a UK tax resident, pursuant to the protocol, that is the situation?
Yeah.
So, okay. Then the reply is no. Because the UK will not tax the inheritance because the heir is a resident of the UK, but only if the deceased is a resident of the UK. Does that reply to you?
I had a question about whether or not I fall into the protocol. I am an Italian citizen hired from Washington in the United States. And the other question, I was hoping if you could actually go over the example of the Belgian succession, because you went very quickly through it to the other countries, and I thought we would have the information in the notes, but we didn't.
No, but you know,
we
could.
Next question there. Yeah.
How does it look like? You mentioned that there are a couple of countries where the taxes are relatively kind, Italy, Portugal, Sweden, and so on. And let's imagine that the kids decide to live in Belgium. So we go to live in one of those nice tax countries. The kids stay in Belgium, and then we happen to die. There is a property, and would the taxation, except for Sweden, because there is no, so assuming that there is no protocol, will the Belgian tax authorities say, okay, we tax it because the heirs are living in Belgium and hence they would like to cease?
Okay, so for Belgium that will not be the case. So Belgium will not tax because of the tax residency of the children, but if the deceased who passes away in Italy, for instance, owned real estate in Belgium, then that real estate will be taxed by the Belgian tax authorities, but only that real estate.
Because I live in I'm Polish, I live in Belgium, and you said that my place of residence determines the tax law, right? But does my tax residence change anything? Because I'm not even sure if I moved my tax residence from Poland to Belgium, you know? But does it have any impact on the inheritance?
So here it depends also, so you are working for the EU institution, and you are covered by Protocol 7 then. You were recruited in your country of recruitment. So normally, if everything was done right, you must be tax resident in your country of recruitment. So you are not a tax resident of Belgium here. So yes, you don't have, except if you have real estate, you shouldn't normally file any tax return in Belgium, I think.
But it depends, I mean, you can cross-check that in CISPER to see if what you believe is your right situation is the one that is already registered here, because when you have questions from the tax authorities, and the only element you have in your hands is the printout that you get from CISPER saying, I am tax resident here.
But whether or not to move my tax residence, perhaps this decision will depend on the inheritance law. That's why I'm asking.
That you cannot do until unless you get retired. As long as you are in the institutions, then your tax residence is set.
Also for inheritance.
Yeah.
Yeah. Also, yes.
So when you leave institutions, you go, or you go in retirement, then the plan protocol does not apply anymore. Then depends where you settle.
Actually, the protocol applies to income taxes and inheritance taxes, and not to gift taxes, which make it a bit more complex and makes our job more interesting.
So in Belgium it is forbidden to draft a joint will I think since Napoleon, because it is a the answer is very simple. It is because we suspect that if you draft a joint will, the most influent partner will influence the other in what he or she will draft. And so to avoid this, we just forbid it. And in other countries, they are more flexible about that. If you die as a French tax resident, France will tax your worldwide estate, and Belgium will not tax your children because we don't tax the heirs based on their tax residence. Belgium only tax based on the tax residence of the deceased, not based on the tax residence of the beneficiaries. So that's.
But your current situation is when your children are minor, they are under your authority and provisions, and they are French tax residents for the time being, and they are covered by a protocol.
Yes, at this moment.